And now, it's The Law Show on CL 650. A comprehensive look at everything you need to know about the law. Now, here's Sterling Fox.
Help! I need somebody. Help! Not just anybody. Help! You know I need someone. Help!
Well, that worked. Good morning, and welcome to The Law Show here on CL 650 as our lawyer guest just lit up like a neon sign when the first word musically of the program is help. It's the Beatles. It's The Law Show here on CL 650, and this morning we're going to talk with Gordon Maynard and Rudy Kischer from Maynard, Kischer, Stojicevic about immigration and citizenship issues. Gordon and Rudy, welcome back. Good to see you both.
Good morning, Sterling.
Good morning, Sterling.
Now, you have just returned from a convention, a gathering of lawyers in Ottawa. It's an ongoing legal upgrade gathering that happens every year in the realm of citizenship law. Tell us about the convention. How recent was it?
It was just 3 weeks ago.
Okay. And immigration lawyers from all over Canada are invited by the government to attend?
No, it's put on by the Law Society.
Okay.
The Canadian Law Society puts it on, and we have, I think in attendance almost 600 lawyers there at that time. I think it was a record-breaking attendance in terms of attendees, and we have government representatives there. The minister himself, Chris Alexander, was there to speak at our luncheon meeting.
Now, was the reason for this record attendance simply the fact that the change pace in immigration law, Gordon, is pretty much at a record rate, and you lawyers are having a tough time keeping up with it all?
Well, actually, there's the continuing legal education is what it's called, and it's the Canadian Bar Association.
Okay.
They hold this every year, and every year it just gets bigger and bigger and bigger because it's very worthwhile. Lawyers who practice citizenship and immigration law gather together, but so do members of the government. They send their representatives from policy and operations, members of various tribunals, ESDC, judiciary. So it's very well attended. I think there were 600 people there altogether. And you talk about current events. And yes, there are current events now. So this one was very popular.
Okay, and the focus, as I understand it, in large part was on the foreign worker program and the whole express entry program, too, that we've discussed to some degree, Rudy, on this program before, but obviously there's a whole lot more to talk about here.
Well, as you know, the express entry program is new, and so it's going through its birthing phase basically, and we're sort of watching it change. And so there were a lot of questions, and we were looking for updates from the government on that.
Gordon, how long has Maynard, Kischer, Stojicevic been in business as a citizenship and immigration law firm?
13 years now.
Yeah.
Okay.
We're coming up to 13 years.
And is the rate of change? I mean, immigration is an area of the law and public policy that is subject to a lot of change at all times. Mm-hmm. But are we in recent years experiencing more of it, or is this just my active imagination, Rudy?
Oh, I would say that you're pretty accurate in saying that the speed of change has increased. For example, this year, the Canadian Bar Association, the national section that puts on the conference, has to prepare papers, talking points that they send to the government on new legislation coming in.
Okay.
And I think this year was pretty much almost close to a record number in terms of sending in 20 papers. So during the last 12 months, they've sent in 20 papers. Where on a typical year, they might send in 4 or 8. So that's the amount of change that's coming through the system now.
At the shop, Gordon, who are you likely to represent in citizenship and immigration cases? Corporate clients or private citizens, or a combination of both?
It's a combination of both.
Okay.
It's a combination of both, absolutely. Sometimes you're dealing with foreign nationals, people who are coming to Canada to work or be students and to transition to permanent residence. Sometimes you're dealing with companies that are trying to deal with moving employees around across borders.
Okay.
Sometimes you're dealing with people who are already permanent residents in Canada or already citizens, or they want to become citizens. They have issues of enforcement. The whole gamut of service in the immigration business is what we do.
Rudy, I don't think many of us are perhaps as aware as we should be about the presence of foreign workers in British Columbia at all levels in the workforce, from the executive boardroom right down to the guy who parks the cars out back. We have an awful lot of foreign workers in our province.
Yeah, we have a lot of foreign workers at every level. There's different programs. So you'll have executives at mining companies that have come over from maybe from South America or from Europe to work here, and they come into under a variety of programs such as international treaties where it's easier for them to come in. But there's also people working at what we would call low-skilled or semi-skilled jobs, such as nannies in the household.
Right.
And currently we have, my understanding is at any given time we probably have about 150,000 foreign workers in Canada. And I think it's also, if you take a look at reflective the amount of permanent residents we have in Canada, where something 19% of our population are actually foreign born. If you take a look at that figure, right?
That is high.
I'd like to clarify a point, though.
Okay.
Foreign workers in Canada, they make up a lot of press right now.
Yes,
in the last year.
No question.
But in reality, the total number of foreign workers in Canada as a percentage of our workforce, very small.
Okay.
Less than 1%.
Overall. Interesting.
Yeah.
And yet there are so many stories in the news regarding foreign workers and public policy surrounding foreign workers and immigration issues. Let me refer to one of the stories in the news. We're going to get into some of the issues that you talked about in Ottawa with the government and with your fellow lawyers. But there are a couple of stories in the news lately that have just caught my eye for your comment. And one of them deals with a nanny who is working here in the Vancouver area who wants to bring her daughter, who's 14 and in the Philippines, to Canada. The mom is a nurse by profession and training, and she works, I believe it's up to 80 hours a week, working at 4 jobs, looking after children, the elderly, a paraplegic client in Vancouver. She's, needless to say, a committed worker who wants to bring her daughter, who's 14 and profoundly deaf, into Canada. And the child, because that's what the law in Canada refers to the teenage daughter as, the child has been rejected by Immigration Canada, deemed medically inadmissible. And Gordon, you and I have talked about medical inadmissibility in the past, but the Immigration Department said that this 14-year-old is medically inadmissible to join her mom here because they estimate that over the next 5 years, were she to live here in the Vancouver area, she would cost Canadians over $91,000 for health-related services over the next 5 years. And the Immigration Department, for some reason, takes exception to that number and says, no, she's not medically admissible. So first of all, what appeal process does the mom have? Or is that it, Rudy? She's made an application for her 14-year-old daughter who can't hear. And the government says, no, she would be too much of a burden on the state. So what does mom do now? Is there an appeal process?
There's not an appeal process of such because she is not a permanent resident. So this is a different scenario where someone's sort of sponsoring a family member. She doesn't have an automatic right of appeal. What she does have after a decision like this, if the decision is finalized, that she is medically inadmissible, the child is medically inadmissible, she can go to federal court. So she can file for judicial review, which is a very high standard to be successful at that level, because the question is not whether the officer making the decision was right or wrong, whether the decision was right. That's not the question.
Right.
The question is, was the decision reasonable, and did the officer who reviewed the case do so in a procedurally fair manner?
Right.
So those are the sort of two major things we've got to look at, and that is a much lower threshold than most people would look at a case and say, well, that's the wrong decision. Well, it's not the question. The judge, when we go to federal court, doesn't look at whether he would have come to a different decision, whether the judge himself looks at.
So the compassionate grounds that pull at our heartstrings are not really considered by the judge at trial.
Well, it's not a trial, so it's a review of the decision to see if it was made okay. So it's not even a trial. It's not like there's no new evidence that comes into effect. What happens is the judge looks at what was before the officer, right? And this can come in the form of usually affidavit evidence and the supporting documents.
Right.
And the judge takes a look and says, well, was this handled reasonably? Did the applicant, in this case the nanny, get a chance to put all the information in? And given the law that's in effect at the time, did the officer come to a reasonable decision? Was that decision they came to reasonably open to him on the evidence that he had in front of him?
You pointed out the fact that the mom, who's been in Canada for quite a number of years, working quite hard, is not a Canadian citizen. If mom was a Canadian citizen, Rudy, would that have changed the texture of the judgment?
Well,
do you think?
we made a massive difference because to go back to how medical inadmissibility works, it is number one, if someone is a foreign national coming to Canada, applying to come to Canada, as this nanny is, so she's here as a worker now, right?
Yes, yeah.
So she's applying for permanent residence. She has to be medically examined herself, and then anybody who's coming as her dependent, so her children, also have to be medically examined. And unfortunately, if any of her dependents, her children in this case, are medically inadmissible, then she is also found to be medically inadmissible. The difference is if she was a Canadian citizen, for example, and sponsoring her daughter, she'd adopted a daughter, or she had adopted
or a natural daughter.
Bringing her natural daughter that she had overseas, and she was sponsoring that child. That she then, number one, the medical requirements are changed for that class of applicants. So if you're bringing in your spouse or your dependent child, they do not. The cost threshold is waived for medical inadmissibility. If they have a horrible disease that could spread rapidly, like Ebola, they may be inadmissible.
Of course.
But if they're going to cost the medical system or social services, in this case, a lot of money, that bar is waived. So that used to be in place almost 15 years now. I think 2002 they got rid of that. So 13 years ago they got rid of that requirement. So it would be a totally different scenario. We wouldn't be having this conversation at all, actually, if the nanny in this case was a Canadian citizen or a permanent resident.
Now the story ends. Both the minister's office and people in the ministry have declined to comment on the case, but they said the mom has been given 60 days to respond to the notice sent to her this week declining the application. So she does have a couple of months. I would assume she'll be talking to a lawyer. Really.
Well, I hope she has one already. I mean, these are cases that we see in our office, and they are, I would say, some of the saddest and hardest cases, because in her case, she's not an applicant that's, the nanny's not working overseas. She's in Canada. She's made dramatic changes in her life, and as you can see, she's worked hard, so she's made a lot of sacrifice to be away from her family, come to Canada with this dream. Unfortunately, the way the system works right now, there is no examination of her dependent children. Right? So people, in this case, come to Canada, and they may not be, I mean, she may have known she had an issue, but she may not have known that she had an issue that eventually, if she's going to apply for permanent residency, that her application could be denied because of her child.
How do you think it's going to end up? Shot in the dark. And I know I'm putting you on the spot here, but how do you think it's going to end up?
I don't know. I think you have to take, every case really turns on the facts. In a case like this, and you really have to look at the daughter and the argument in terms of what is the daughter really going to cost. And I think the problem when we come to a case like this about deafness, and we're looking at social services, the question is, how much is that child going to cost us, right? And we have in Vancouver a school for the deaf. I was just going to
say, you know, it's not so bizarre a medical condition that Canadian science hasn't reached out and managed to find a way to deal with it. Right. We have a school for the deaf in Vancouver. This woman lives in the Vancouver area.
Exactly. So the question becomes, how much extra is this child going to cost? And I think what happens, I find in a lot of these cases, is the government takes a rough number that's ready through a grading system that's set up by the provincial government, saying we're going to give every school board, you know, for this type of condition, we're going to give every school board $6,000. But it doesn't look at the actual cost of that child. What they've done is they have a simplified formula to say, okay, you know, this is what we're going to provide for the school board to take care of this child. It's not what that child is going to cost. And the Supreme Court of Canada says it's an individualized assessment. You have to look at, you know, how functioning is that child.
Right.
If she's somebody who needs, you know, a caregiver beside her for the entire class, well, that, you know, that's going to be hard for this person to overcome. But I think the argument that might be open to her in this case is that the fact that, you know, those costs aren't going to be that high. The government's saying it's going to be $90,000.
Right.
I think she might have an argument to come back and say, listen, we've taken a look, we've talked, because the school board has come out here, and the School for the Deaf, from my understanding, have come out and said it's not going to cost us anything extra. Right? You know, that this is the average cost of a student, and that'll be covered.
So you think in this case, in the mom's corner, there might be a little bit of hope?
I think there's hope.
There would be some.
I think there's some hope. I think it's a hard case. I mean, these cases are always hard cases.
Sure.
And you know, and it really depends, sort of, you know, where her daughter is. If the daughter was maybe fully signing in English, then the cost would be a lot less, right? If she has to learn sign language, well, that's like learning a new language. What's the cost on that?
Right. Well, she's been profoundly deaf since birth, so apparently she functions pretty well. Mom says she's a pretty normal kid. Yeah. We'll keep an eye on this, Rudy, and we'll follow it as it goes forward. She does have 60 days to now. Would she be requesting that judicial review?
No,
not during the 60 days.
No,
that's after the
so
decision.
there's been no final decision. So the officer said, you know what, this is our opinion.
Okay, so now she gets to go. Wait a second. No, I think you're wrong, and here's why.
Yeah. So it's called a fairness letter, and the Supreme Court Canada says they have to give you a fairness letter.
So she's got a couple of months to work
out
a response.
And hopefully she's retained a lawyer to sort of advise her on this and make those submissions, I would hope.
We're talking citizenship and immigration law issues this morning on the Law Show here on CIL 650. Our guests from Maynard, Kischer, Stojicevic, Gordon Maynard, and Rudy Kischer. The first news story, and it was a good one too, right from here in the Vancouver area on the matter of medical inadmissibility. And Gordon, when we come back from the break, we're going to turn things over to you and talk about, the marriage fraud inadmissibility matters that the Immigration Department has. Are they really in love, or are they just faking it for the government so somebody can get a Canadian passport? Back after this on CIL 650.
There's more of the show still ahead. This is The Law Show on CIL 650.